Good morning, everyone, and welcome to our Hull and Hull Breakfast Series. I'm Susanna Popovic-Montag, and I'd like to take this opportunity to welcome all of you who are joining us here in person today, to those of you who are joining us by webcast, and to those who are listening on the phone. We are very grateful that you could join us, and to those who actually attend here in person, that you took on the torrential rainfall that's out there and survived past the power outage and still made it here. So it's great to have you here with us. I'd like to, just before we get started with our formal program, take an opportunity to introduce those of our firm members who are here, just so that we could put a name to a face in the event that our paths cross. We have, and I'll just ask you to either raise your hand or to stand, Rick Bikram. We've got Natalia Angelini, Julia Evans, Jordan Ayton, and our clerk, Heather McGuinness. So thank you very much for coming, all of you. And what we've done is, in order to spice up the morning a little bit and wake you all up, we're going to address the speakers in reverse order, or actually maybe even a little bit more than reverse. So we're going to ask Sharon Davis to speak first, and she's going to talk to us about handwritten changes to wills.
Normally I just get to stand up and raise my hand, but I have the privilege of actually speaking to you this morning, so welcome. For those of you who draft wills, you know the drill for drafting a will. I'm going to call it the will drill. So a client comes into your office, you ask all the right questions, you take instructions, you take copious and impeccable notes, because after all, you don't want to come back to Hull and Hull with this will later on. Next, you draft the will using all the right language, technically and legally correct. You've got no typos, no dangling participles, everything's good. Now your client has a mind like a steel trap, no capacity issues, no undue influence whatsoever, and he or she understands everything you're telling them absolutely perfectly. Client is exceedingly pleased with your excellent work and your excellent work product. She signs the will, and she has her will, of course, witnessed by two subscribing witnesses in the presence of one another. Voila, you have the perfect airtight will. So you send her off with the will and her affidavits of execution. Everything's great. You can pat yourself on the back for a job well done, until, fast forward a few years later, the family comes back in with the will, and it seems as though Mom wanted to change a few things on the will. Well, she's passed away peacefully from old age, and really, I think, as we get older, and certainly human beings in general, feel entitled to do what they want with their property. And I think clients fail to understand that. In order for a will to be valid, you have to comply with all of the requirements of the law. So you say to yourself, well, you know, what was she thinking? Clearly, it's a momentous occasion when you're signing a will. And I don't know about you, but the only time I can ever remember having two people witness something is when I got married. So it's a pretty big deal. Like, you think people would understand this. But not so. She's had a couple of changes of mind, and she's scribbled on her will. I've actually seen a number of cases lately where there have been changes on wills. And it's something that as lawyers we understand that you shouldn't do, but I don't think clients really get it. I guess what you really have to make sure clients understand is that their wishes can only be carried out insofar as the expression of them complies with the law governing wills and estates in their jurisdiction. Now, you can be pretty proactive with this, and I'm sure all of you who draft wills do so. You explain all of this to your client when they come in, except they don't think about their will as much as you think about their will. You explain the kinds of situations that might require a will change, and certainly if there's going to be a change, it shouldn't be in handwritten notes all over the will. It really should be by a properly drafted codicil. At the very least, the changes should be witnessed by two subscribing witnesses, just like the formal will is in the beginning. Now, the kinds of situations in which changes might be required would be divorce, marriage, births, deaths, adoptions, name changes, significant financial circumstances changes like disposition of assets or maybe acquisition of assets. Even just the passage of time, things can change. So what do we do about this problem? Well, your client's gone off with their will and they've forgotten that they really shouldn't be writing on it or doing anything with it. At regular intervals, those of you who actually have will banks or client lists would do well to contact your clients regularly. Now, the time period for contacting your clients would probably depend on their age and their circumstances. But you really have to think that this is a great opportunity, not only for good client service and reminding your clients of what they should and should not be doing with respect to their affairs, but you can update your client information so you have current addresses on file. You can remind your clients of the services that you provide, so it's a really great marketing opportunity as well. Okay, so what if in spite of all your efforts, you've got this will with changes on it? Well, there are only two ways that such handwritten changes or holograph changes on a will can be valid. One is pursuant to Section 18 of the Succession Law Reform Act. If the changes are made respecting the same formalities as are required for the original execution of the will, and that means they're observed by two subscribing witnesses, and those witnesses sign either in the margin near the changes or in a memorandum somewhere else in the will when the memorandum refers to those changes. That would be a valid alteration. Otherwise, pursuant to Section 6 of the Succession Law Reform Act, those handwritten changes can actually form their own codicil. Now, in order to be valid, they have to be wholly in writing, and they have to be signed by the testator, no witnesses required, and they have to be capable of standing on their own. And I think this is something that a lot of people don't realize. They want to scratch out Aunt Eunice and they want to put in, Uncle Joe. That in and of itself is not sufficient. It's got to stand on its own without reference to the other printed material in the will. And it also has to indicate a firm testamentary intent. Now, it's one thing to write on a will, but it's another thing to write handwritten notes that might not be on the will. And this causes a little bit of a difficulty as well. In fact, if you have a client who you know is like a list maker, I'm guilty of that, or someone who really likes to organize things and wants to leave all kinds of information behind for others, you might want to, that might be a little bit of a red flag for you. Anything that complies with Section 6 of the Succession Law Reform Act and the other requirements, being testamentary intent, could actually be a holograph codicil or a holograph will. In fact, we had a case just a little while ago, and every time we had a new piece of paper, it was a new testamentary document. And you're going, okay, we're up to 5 now, because this woman wanted to make absolutely sure, along with her handwritten will on which she had written, that the person who was going to be taking care of her affairs knew exactly what she wanted and where to find everything. And we ended up with a number of different holographic writings that could be interpreted as testamentary documents. I think, too, the do-it-yourself age has caused us some difficulty. Certainly with will kits, we all know that that causes some trouble. But I recently saw, and I actually couldn't believe my eyes, there's a book out there, and it's called When I'm Gone. And I'm just going to read to you what the description is. It's a record and resource book to help family and friends handle the details of life when someone dies or is away for an extended period of time. It includes space for contacts, location of documents, wills, medical records, pet care, finances, and property, home and vehicle maintenance, passwords, end-of-life wishes, and funeral arrangements. And it's 144 pages long. And I'm thinking that's 144 pages of opportunity to mess up your will. So you really have to think about what kinds of things can cause trouble. Now, in my paper, I've provided guidance from case law, and all of these cases are mentioned in there. I'm just going to take you through some of them. One of the more recent cases is CIBC Trust versus Horn. And this is a decision, a 2008 decision by Justice Nolan. And there's a very helpful review of the law in general on revocation and alteration of wills, and on holograph wills, and on the doctrine of substantial compliance. In this particular case, CIBC Trust was the named estate trustee, and the will, of course, was properly typewritten, executed. There was a codicil as well, also done properly. However, subsequent to execution, the testator decided that she would make some handwritten changes and made them over, it would appear, a period of time. There was different ink. The changes were totally inconsistent. She crossed out some things. She changed some names. So there was really no rhyme or reason to what she'd done in the will. The trustee commenced an application for advice and direction. And at the end of the day, the will was sent to probate in the exact same form as it was originally and properly formally executed. So none of the handwritten changes had any effect whatsoever. And the reason for that, essentially what I told you before, either it has to be a proper alteration or a standalone holograph codicil. Some of the points that the court made, however, were very instructive. For example, to be duly executed, a will must be in writing and signed. There's a presumption of validity when a will is regular on its face. Intent is a necessary element in revocation. And so that means if you're going to have intent, you have to have testamentary capacity. And so any changes would have to be by someone who has the proper testamentary capacity to make a will in the beginning. And certainly I've seen other cases where people may have scribbled on the will and not known what they were doing, i.e. they didn't have capacity. And in such an instance, you know, it would be likely that kind of thing would not qualify. Another important thing is the word apparent, as it's defined in Section 18 of the SLRA. Apparent means apparent on an inspection of the testamentary instrument and not by extrinsic evidence. So the provisions of a will may be revoked by obliterating or otherwise rendering some provision no longer apparent, as per Section 18. So this means that just by looking at the will, not by any sort of extraordinary measure or other, technological interference or product that might be able to discern what's underneath. If it's obliterated to the naked eye, then that would be no longer apparent. Alterations made before the execution of the will may form part of the will, although not duly executed or initialed, but the burden is on the person who is seeking to rely on the fact that those changes were made before the will was properly executed. If an alteration has rendered some part completely not apparent, then that piece of the will not go to probate. So what will happen is the court will read the will as if that piece or word or words had never appeared in the will. A holograph will has to include a signature. And normally that signature is at the end of the will, but it's not invalid if that signature appears someplace else in the will, according to section or subsection 7.1 of the Succession Law Reform Act. Another thing the court had mentioned, and I found this interesting, is that courts in Ontario actually do not have the same discretion that exists in some other jurisdictions in Canada, where legislation allows the courts to dispense with formal requirements of the will if there's a document from which the deceased testamentary intention can be determined. The Ontario courts don't have that discretion to dispense with any of the formalities. As by way of example, in Cote Estate, a 1987 decision by Justice Sheard, they were unable to admit to probate a clear typewritten instruction sent by a testator to her lawyer regarding changes to be made to her will. And even though her intentions were clear, the typewritten instructions were neither a holograph will nor a properly executed will. With respect to firm testamentary intention, if a testator understands how a will is to be changed, and certainly in the case of CIBC and Horn, this testator had actually done wills before, and she had done codicils, so she understood what the process was for changing a will, and so those other changes then could not be taken to be a firm intention of what her testamentary wishes were. The next case in my paper is Lutty versus McGill, a decision by Justice Greer. And this was on a pre-printed will form. Although the pre-printed will form had been properly executed, further changes were made after that proper execution. So, again, the factors in play were that the alterations made were excluded unless they were either witnessed or they were a holograph will that could stand on their own. In that decision, the court referred to a decision of King versus King and Fleming, and that's an Ontario General Division decision of 1995. Where a will excluded certain named persons from a class of beneficiaries. And the interesting thing about this case is that the court found it was not necessary for a codicil to be dispositive of assets. So it could be a change of executors or a direction to the executor to do something, and that also qualified. So if the writing is equally capable of being either a holograph codicil or an alteration, it should be construed to give effect to the testator's actual or subjective intent so as to avoid intestacy. And with respect to a signature, in Coat-Estate as well, initials were found to be sufficient signature for the purposes of the legislation. Now, notes. There's a case in here with respect to a note written by a mother to her daughter. And this is Owers versus Hayes. There was a note written in 1969. Now, in 1968, the testator had done a formal will. And at the time, she was a widow. But she did have a boyfriend. And she did her will, and there was no contemplation of marriage mentioned in the will. In 1969, she did a note to her daughter. And the note said, just in case I do marry, if anything ever happens to me, she wanted her husband to live in the house rent-free. So a life interest, basically. Now, the formally executed will left everything to the daughter, who was an only child. Normally, obviously, marriage will invalidate a will. But in this case, the court found that the note to the testator's daughter constituted a valid holograph will, a holograph codicil made in contemplation of marriage, because she had mentioned, if I marry the person that she did, I want him to have a life estate. And so it revived the earlier will and stood alone as a holograph codicil. The court found that the test of a holograph is intent, and the intent was clearly expressed in the note to the daughter. And the court found that, accordingly, it was a valid holograph. Now, I have some other case law in other jurisdictions here that you might want to refer to. They all really do refer to the same kinds of tests and the same sort of information. I might just hit on a couple of highlights of those. Laidlaw Estate is a decision of the Alberta Court of Queen's Bench. And again, a typewritten will that was formally signed and witnessed, and unwitnessed handwritten changes were made. There were some errors in the spelling of the name of the daughter and the granddaughter. However, the court found that really didn't make a lot of difference, because there was no doubt really as to who the testator was talking about. In that case, again, the handwritten changes stood on their own and were to be probated as a holograph will. In a recent New Brunswick Court of Queen's Bench decision, Stackhouse Estate versus Lafleur, the marking was on the will had been done with like a black marker. And the black marker, permanent markers tend to be pretty dense. That marking was not witnessed or initialed. And again, this case dealt with the meaning of apparent. And in this case, apparent meant optically apparent on the face of the document itself by natural means, such as holding it up to the light or using magnifying glasses. It did not mean capable of being made apparent by extrinsic evidence or any artificial means. And therefore, any original provision that could be deciphered stood, and any obliteration was excluded. Now, with respect to procedure, what do you do if you've got a will that has markings on it? The proper procedure is to do an affidavit of condition. And I've appended one of those to my paper just for your information. You have a subscribing witness explain that the will has had certain alterations made after it was witnessed. There is a case by Justice Brown that is illustrative of a affidavit of condition. In that case, it was called Walbridge Estate. And in that case, the markings, I think, just had an asterisk with deceased by a couple of the beneficiaries. It wasn't really obliteration or anything that would be something that would be contentious or that would be particularly difficult to discern what was meant. And so it was done over the counter, but the estate's office refused to accept the application because there was one affidavit instead of two affidavits. So instead of an affidavit of execution and an affidavit of condition, everything was in the one affidavit. And Justice Brown found that that is perfectly fine. All of the information that you require is in there. So that might simplify things a little to have one affidavit instead of two. I think he likened it to certs. What was it? Two affidavits in one. A breath of fresh air. Okay, so that's it for my handwritten changes to wills. And if you have any other questions, there's certainly a lot of case law out there on this. I happen to find it fascinating because I think, as David calls me, I'm a law geek. But in any event, if you want any help with anything else, I'm available for questions. Thank you.
Thanks very much, Sharon. Our next speaker is David Smith, and David's going to be speaking about family law issues and their impact on estates, and that's the first paper in our package.
My topic is admittedly extremely broad, and when asked to give a title for my paper, I, of course, hadn't yet done the paper. So I said, well, I'm going to do something about family law issues because I've been giving a lot of thought to various things that come up in the course of our practice. So I've refined it a little bit. The actual title that I've given to the paper is Spousal Issues for the Estates Practitioner. And what I thought I would do today is look at the relationship between married couples and the considerations that need to go into the drafting of wills, the administration of the estates, and what kind of issues to flag when you get into the gray area where a couple may not be divorced, but they're separated, and you've got this awkward situation where there's a separation agreement and there's a will, and how do these things interact in the unfortunate situation where someone has passed away, still separated, not divorced, and with a will that predates the separation agreement. So starting first of all with the idea of a joint retainer and the idea of married couples typically coming to your office in the traditional scenario where they come to your office to make mirror wills. There's been a fair bit of commentary over the last few years, and it crystallized in 2005 when Convocation made an amendment to the rules of professional conduct as to how solicitors drafting wills are to consider their obligations when a husband and a wife come to their office to make wills. And Convocation has clearly set out that that is a joint retainer, and if you're retained by a husband and wife to make mirror wills, you're in a joint retainer situation, which comes with an obligation to advise each party to the joint retainer of any communications passing to you from one to the other. And so if you get into a situation where a married couple make mirror wills and then one of them comes back to you and wants to change that will, convocation is pretty clear that that would be subject to the joint retainer. If someone comes to you and wants to make a new will, that would be a new retainer, but if they were originally parties to the joint retainer, you have an obligation not to act in circumstances where the new retainer would in any way be in conflict with your obligations to the other spouse. And I noticed that just by the by, my partner Susanna Popovic-Montag wrote on this very issue in the TLA Journal. So for those of you who get that, I know I get it by email. There's a good piece by Susanna on that issue as well. And so I think what's useful just in terms of the big picture, I know we're all familiar with the idea of the joint retainer and that obligation which carries with it various responsibilities, but it speaks right away to the obligation that we have as lawyers to make sure that we inform married couples of their rights and obligations. And the joint retainer is one of those situations. And certainly at the outset of the retainer, there's an obligation on you as a lawyer, and we all know this, to inform the spouses of the implications of a joint retainer. And namely, if you come back to me and you want to change the will, I'm going to have to let the other person know, and that's the reality. Now, the other obligations that we have advising married spouses is to convey how statute imposes on married spouses an obligation to benefit each other and to provide support for each other. So not that we don't see wills where spouses, husbands and wives, cut each other out of their estate, but certainly we're all familiar with the Family Law Act, the Succession Law Reform Act, both of which provide that there's an obligation. I mean, Section 30 of the Family Law Act clearly says there is an obligation to provide support. We're familiar with that. And on death, if a spouse is not adequately provided for in a will, then we know that there's an obligation to provide support that's afforded by statute. The remedy is an application under Part 5 of the Succession Law Reform Act. And there's been a lot of commentary about how that support obligation has expanded since the Court of Appeal came down with a decision in Cummings. So the relationship between married spouses provides challenges to lawyers. If you're advising clients at the outset, it's kind of trite to say that they need to understand that if they choose to cut each other out, and clearly that wouldn't be in a joint retainer situation, but if a married person came to you and said, I want to make a will, I want to cut my spouse out, clearly there would be a very detailed reporting letter advising why this probably isn't a good thing to do, and that if it is done, there's going to be remedies afforded to the married spouse. Now, the next situation I want to touch on is one that's fairly straightforward, rarely encountered, I think, in practice, but it's the situation where someone comes into your office, says, I'm going to get married, I'm in a common law relationship, and I want to make a will, and I want to make sure that this will is in contemplation of my marriage because I'm not sure when I'm going to get married. And so it's fairly standard, of course, that as long as there's a contrary intention in the will, it will not be revoked by the marriage of the testator. And so if the testator comes into your office, makes a will, the will says expressly it's made in contemplation of marriage, we know that that will is not revoked if the parties actually marry. In fact, the making of the will is entirely consistent with the terms of the will, which says it's made in contemplation of marriage, rather self-evident. The wrinkle, I think, is a situation that can arise, admittedly in rare circumstances, although a little more frequently given modern society, and that's one where will is made in contemplation of marriage, and tragically the testator dies before the marriage ever takes effect. And so the issue there is that will valid? Because the marriage never occurred, and the courts seem pretty clear to say, well, yeah, that's a valid will. The contemplation of marriage clause contained in a will doesn't make it a conditional will. The will still survives whether or not there's a marriage. It's more of a demonstration of intention that if there is a marriage, the marriage doesn't operate to revoke the will. That being said, I mean, every case can be distinguished on its facts, and I think counsel of caution would probably suggest that any time you make a will in contemplation of marriage, my thought would be that the reporting letter to the client should say, look, if you never marry and you die before you're married, theoretically, the will could be vulnerable to attack on the argument that it's a conditional will. Admittedly, it's a weak argument, but the difficulty I think you might have is if you don't put that in your reporting letter, and admittedly it's a very cautious approach, but I think we're all directed towards that. If you don't put it in your reporting letter, there is a recent reported case which deals with an issue where a disappointed sibling of a testator challenged the will on the basis that it was a conditional will, that the will failed because the contemplation clause, as I call it, did not manifest itself in the sense that there was no marriage. Now, admittedly, the authority seems pretty clear that that's a weak basis upon which to challenge a will. On the other hand, probably from our perspective as litigation lawyers, we're all into risk avoidance, and I think from a practice point of view, it's useful to just put in the reporting letter, if it's a will made in contemplation of marriage, that this clause is in there because you're going to get married. Of course, we don't have any control as to what happens after the client leaves the office, and so there's always some risk that the person will pass away before they're married. So a sort of minor point, but one I think worth flagging. I want to turn now to the sort of meatier part of my talk, which is dealing with the whole issue of separation agreements and this kind of gray area that I set out at the outset between termination of the marriage, well, not termination of the marriage, separation and divorce. If we consider the other end of the situation, contemplation of marriage clauses are clearly made in contemplation of getting married. Section 17, sub 2 of the Succession Law Reform Act is clear that if a marriage ends in divorce, that any benefit passing to a married spouse is terminated by the divorce. The will still survives, as we all know, but the gift to the spouse is terminated. There's a recent decision of Justice Brown, and I was kind of waiting for Sharon to mention Justice Brown because it seems that every person who talks on estates these days has some reference to a decision of Justice Brown, and there's a decision that he's made that impacts upon this area, which is a case called Roth Estate, R-O-T-H, and the site for that is 51 ETR 3rd 290. And it's actually a fairly straightforward decision, but I thought the fact situation was kind of useful for us to consider in terms of illustrating this point I want to make. In this case, the will was made in 2004. In the will, the testator provided for monthly payments on his death to his wife of $10,000 a month to be increased annually by the cost of living. In 2005, there was a separation, and the separation agreement essentially mirrored the will, except it said that you could vary the support entitlement. The parties divorced in 2005, and the husband died in 2007. And what happened in this case was that the estate trustee applied to the court to vary the support payments to the wife. And the wife said, well, hold on a second, you can't do that because there's a will that says I benefit, and there's a separation agreement which is consistent with the terms of the will. And to his credit, counsel for the wife, I thought, came up with some rather clever arguments, although Justice Brown, being Justice Brown and looking at it very logically and with reference to the statute, said, look, it doesn't matter what the will says. The benefit to the wife was terminated the day that the parties divorced. And so because there was a divorce, this was a situation where the separation agreement governed the relationship between the spouse and the estate. And so the court actually varied the support payment to the wife on the basis that the separation agreement provided that remedy to the estate. And so it's a cut and dry situation if there is a divorce, because Section 17.2 of the Succession Law Reform Act is so cut and dry. And that was basically Justice Brown's point. He heard the submissions. In his ruling, he indulged counsel with an examination of the analysis, but ultimately shut it down because he just said, look, the will does not survive, end of story. By far the more complicated cases are those where there's not a divorce, there's a separation only, and you're in that gray zone where there's a separation agreement, there's a will, and the estate trustees in the situation where they say, well, what am I supposed to do in this circumstance, and what's the impact of the separation upon the will? Now, separation agreements kind of get a bad rap, I think, because there's this sense out there that domestic contracts can always be set aside. But there's been an awful lot of decisions by appeal courts lately which actually are tending to uphold the validity of separation agreements, domestic contracts. And so the issue is, can a spouse contract out of his or her entitlement to receive something under the will? That is to say that if someone separates from their spouse, signs a comprehensive separation agreement, but doesn't make a new will, can the separation agreement have the effect of causing the spouse to have contracted out of his or her entitlements to receive a benefit? And the answer is yes, but it's got to be a very carefully drawn document, and the court will scrutinize it extremely carefully, especially in the case of an intestacy or in the case of a prior will. And so the message here, if there is one, is that if there is a separation agreement and somebody passes away and comes to your office with a separation agreement and a will, there's not much you can do to change that situation. And so legal advice may be necessary to find out if the separation agreement overrides the will. The best practice point, I think, and this really requires, and there is discourse between the estates bar and the family law bar, but certainly the best practice point, the simplest one, is you make a new will after there's a separation agreement, because then you lock down the effect of the separation agreement. You don't leave any uncertainty. But I can tell you, certainly in our practice, we've seen numerous cases where that doesn't happen. And quite frankly, what it does is it generates work for lawyers, unfortunately, and causes expense to estates because there is a legitimate question and a lot of reported cases on this very issue. And so the issue isn't just to what extent you've contracted out of your entitlements to be a beneficiary under a will, but to what extent the separation agreement impacts on beneficiary designations as well. And so then you get into the interplay between the Insurance Act and the validity of the contract, and it's clear that a separation agreement can be considered as an instrument under the Insurance Act. And for that reason, if a separation agreement speaks to an intention to terminate a beneficiary designation on file with an insurance company, the courts will honor that. The difficulty is that, especially with RRSPs, the statute is clear. You've got to be very specific in the separation agreement as to what extent and with what certainty you've set out that you want to terminate a beneficiary designation. I'm always equitably minded because it makes for fun legal arguments, quite frankly, but the problem is courts are not receptive to them, except without broad brushing it. In B.C., there tends to be a little bit more receptiveness to arguments based on remedial resulting trust and constructive trust, and the suggestion that even if someone is beneficiary under life insurance policy, let's say, and the separation agreement appears to show an intention not to benefit the spouse with very broadly worded releases, the statute is clear that there's just no getting around it. And I suspect most of you are the same as I am with my clients. They say, look, estates and trust law is a very black letter area of the law. If you make a will, you've got to have two witnesses. If you make a beneficiary designation, that beneficiary designation is going to prevail unless you play by the rules of the statute. That being said, it is a court of equity, and there are arguments based on the facts where you can try and argue in certain situations that the course of conduct of the parties was such that, notwithstanding the fact that the rigors of the statute were not complied with, there's a reason in a certain case to provide a beneficiary to someone other than the named beneficiary. And certainly separation agreements are one area where you consider the agreement itself and all of the various factors. So I think that wraps up my paper. I just wanted to leave you then with some thoughts as to issues that might arise in those specific areas, and I hope that's of some assistance. Thank you.
Thank you very much, David. And our last speaker today is going to be Paul Trudell, who's going to speak on suicide notes, and testamentary capacity.
Thank you, Susanna, and thank you for coming out today. In researching this paper, I had the occasion to look at a number of suicide notes left by the rich and famous and not so rich and not so famous. One of the more noteworthy notes that I came across is the suicide note / will of the late French writer Francois Rabelais, who died in 1553. And upon taking his own life, he left a one-line note that read, "I owe much, I have nothing, the rest I leave to the poor." Now, this note is great on many levels. The first is that it identifies how to avoid estate disputes. Owe a lot and don't have anything. Secondly, it touches upon a number of the issues that I want to address today with respect to suicide notes and whether they can be testamentary, the formal requirements of the suicide note as a valid will, testamentary intent, and testamentary capacity. The genesis of this talk was a discussion we were having at one of our Hull and Hull lunches, and Natalia Angelini mentioned, where are you, Natalia, mentioned this, the high number of cases that we're seeing lately that involve suicide and suicide notes and how troubling that is. And we all agreed that it was a phenomenon that we were noticing an increase of as of late. And because of that, we thought we'd have a discussion today on the topic and the issue of suicide notes and their validity. The statistics on suicide are quite staggering, and I won't go into them in too much detail, but globally, someone commits suicide every 40 seconds. In 2008, 815,000 people committed suicide, and that's more than double the amount that have been killed in armed conflict. For people between the ages of 15 and 44, it's the fourth largest cause of death and the sixth leading cause of disability and infirmity if the suicide's unsuccessful. Canadian suicide rates are said to be between 11 and 15 per 100,000 people. The statistics with respect to suicide are quite staggering. Suicide rates are higher for certain groups of people, and the numbers that I gave are for the general population. We know that suicide amongst the elderly is a more common phenomenon, and their suicide rates are higher. We're probably going to see a time when the baby boomers are now entering into the age where they can be classified as elderly, so we're probably going to see an increase in the amounts of suicide as the number of elderly increase. Anecdotally, we also know that baby boomers, as they age, may not be as prepared to settle for a lifestyle where they're not at their best and not in control, and they, as other elderly do, may succumb to the temptation to terminate their lives rather than tolerate a miserable old age. We also know that people are living longer, and there may be a tendency to outlive their finances or their monetary assets, and that may lead to an increase in the amount of suicide amongst the elderly. In our lifetime, or my lifetime at least, we've seen a significant change in how suicide is perceived. In Canada, it's noteworthy to note that suicide or attempted suicide was a criminal act until 1972. This criminality of the act was based on ancient and long-standing church doctrine that to take a man's life, for a man to take his own life, was an offense towards God, an offense towards the sanctity of life. That church doctrine was reflected in early psychiatry, where suicide was seen as a sign of moral and mental weakness. In my paper, I talk about the historic impact of suicide. Until 1823, an individual who committed suicide was denied the right to be buried on consecrated ground. They were buried at night at a crossroad with a stake through their heart, and their possessions were confiscated by the Crown. It was seen as a moral shortcoming on the part of the perpetrator of the suicide. This, as I said, changed over time, and ultimately suicide attempts were decriminalized. In 1972, the decriminalization reflected a change in thinking with respect to suicide, and rather than blaming the perpetrator of a suicide attempt as being blameworthy, the view was that they were a person to be pitied and seen as a victim. It was about that same time in the 70s that the Roman Catholic Church actually changed how they view suicide as well. In the 1997 Catechism of the Catholic Church, the Church softened its position on suicide and said that the person who committed suicide may not be, quote, fully right in their mind and thus not 100% morally responsible for their suicide. So there was a softening in criminal views and religious views on people who, on attaching blameworthiness to committing suicide or attempts. So suicide was no longer seen as a criminal act to be dealt with by the legal system, and was seen as a mental health issue to be dealt with by the mental health system. However, this shift of treating suicide as a mental health issue has a substantial impact on state law and how we deal with suicide victims. The issues that arise when a person commits suicide and leaves a suicide note or makes a will at or about the time of the suicide are whether the note can be considered a valid will, and did the suicide victim have the requisite mental capacity to make a will at the time of he made the will, shortly at or about the time of suicide. It's clear from the case law that a suicide note can be considered a valid testamentary instrument if it meets the requirements of validity set out in the Succession Law Reform Act. And Sharon spoke about some of those requirements. If the note's not a handwritten will, it must meet with the requirements that it be signed by the testator in the presence of the two witnesses, who must also sign in the presence of the testator. However, in the case of a suicide, the more common outcome is that the note isn't a formal will, and that level of preparedness doesn't go into the act of making a will or leaving a suicide note. Normally we see a handwritten note that's left by the testator, signed by the testator, and the question is whether that can be a valid will. I say that the common practice is to leave a handwritten note. I'm sure that now we're going to be seeing more Twittered suicide notes. At least there's no question as to whether they're going to be considered wills or not. On technical grounds, under the Succession Law Reform Act, the suicide note, if it's in the handwriting of the deceased and signed, can be considered as a will valid under the Succession Law Reform Act. So if we have that circumstance where there's a handwritten will and it's signed, it may be considered a will as it meets the technical requirements. The second requirement, however, is that in addition to due execution, is that note must have testamentary intent, or animus testandi, to use the Latin term. In order to have that testamentary intent, there's a number of requirements. First, there must be the intention of the writer to convey benefits by the note. He must be disposing of his assets by way of that note. And secondly, it must be that his or her death is the event that gives effect to the note. Precatory notes or notes setting out wishes and hopes will probably not be considered to be testamentary, and letters that do not express a deliberate and final intention to deal with assets won't be admitted. A good illustration of how the courts will look at and apply testamentary intent is the case of Quirk and Wernicke. That's cited in the paper that I have that I prepared. It's a Saskatchewan case from 1983. There, the deceased took his life at the age of 44. He had 6 children at the time, between the ages of 16 and 23. Enough said. He also had a wife of 24 years that he loved, or was said to have loved very much. Before he died, about 8 months before, he prepared a handwritten will that was signed by 2 witnesses. So even though it was a handwritten will, it was made with some formality and could be considered a formal will. It was properly attested by the witnesses. In that will, prepared 8 months before he died, he left his entire estate to his wife of 24 years. To complicate matters, however, after he made that will, he attempted suicide, and at the time he attempted suicide, he left a note that was signed by him. In his note, he said, "Mary," his wife, "goodbye, my love. I leave everything to you and the boys." The boys. So we threw in the boys now. The first will was to the wife. Now he has this note that leaves everything to Mary and the boys. To further complicate matters, I said he had 6 children. 2 of them were girls. So what we have is a will that was probably properly executed, that leaves everything to the wife, a note that leaves everything to the wife and the boys, and if there was an intestacy, the estate would go on an intestacy to the wife, the boys, and the girls. So everyone lawyered up, and the matter arrived at court. The first issue that the court dealt with was the testamentary intent of the suicide note, the note that left everything to Mary and the boys. The court found that in the circumstances of the case that note, although it appears to have dealt with property, did not have testamentary intent. First, the court noted that the prior will that was left by the deceased was signed by 2 witnesses and was quite formal. The court found that, or held that, the suicide note that didn't have that formality was probably considered by the deceased to not be a will, because if it was to be a will, he would have gone through the same formalities. Although I note that there's no requirement that the testator actually go through those formalities in order to make a valid will. The second note is that after he made the note and there was the attempted suicide, the police arrived. The police took the note as evidence and kept the note. The deceased didn't make any attempts to try to get the note back, and the court held that if the deceased did feel that the note was testamentary or was to have testamentary intent, he would have taken some steps to try to get the will back. The third ground that the court relied on to find that there was no testamentary intent was that the deceased kept all of his important papers in his desk in a file, and there he had his tax returns, a listing of all of his assets, and the will that he prepared. The testament, the suicide note, wasn't there. And finally, the deceased spoke of his will in the weeks before his death and told his wife that he had left the will and everything was to go to her. So based on this, and even though the suicide note would appear to be testamentary on its face, the court found that there wasn't the requisite testamentary intent, and therefore the suicide note wasn't found to be a valid will. The lesson from that is that even though something on its face may appear to be testamentary, we need to ask the right questions and get the full story so that we can determine whether there was that testamentary intent. Another case that tests the doctrine or tests the application of testamentary intent is another case where there was not necessarily a suicide note, but the deceased took her own life and left a note that had a list of names, and beside the names there was a list of property, presumably property that the person wanted to give to those people. Beside one of the names were the letters EX, which the court accepted as meaning executor. On the initial hearing, the court found that the note was not a valid testamentary instrument because it didn't have the requisite testamentary intent. The court set out the proper rule, as set out in a number of other cases. Quote, "The holograph will is not testamentary unless it contains a fixed, final, and deliberate expression of the intention as to the disposal of the property on death." So that's the threshold that the note has to reach. The court at first instance felt that this list was just a list and it didn't quite meet that threshold. On appeal, the court admitted further evidence, and on the appeal there was evidence put forth by a neighbor of the deceased who took his own life. And the neighbor gave evidence that the deceased had given him a key to his house just before the deceased took his own life, and told the neighbor what documents he would find in the house. And that's when the neighbor found this list. There was also a couple of memoranda from law firms that the deceased was able to get from articles that set out how to make a will and was required for a will. The court relied on that evidence to find that there was convincing evidence that the writing in question was intended to be testamentary. So again, we need to go beyond what appears on the face of the note and look at all of the surrounding circumstances in order to determine whether there is that requisite testamentary intent. Now, if we assume that a suicide note meets the requirements of formal validity under the Succession Law Reform Act, and assuming that there is necessary testamentary intent, the next question, and the big question, is whether there is testamentary capacity. Now, if I quote from Hull and Hull on probate practice, and I have to do that every breakfast seminar, that's one of the requirements, there it said that from time immemorial it has been the law of England that no person of unsound mind is capable of making a will. And we can't go beyond time immemorial. The basic rule is set out in the now famous case of Banks and Goodfellow, which is also known as Lord Coburn's rule with respect to testamentary capacity. The testator must meet these 5 requirements. There must be an understanding of the nature of the will or codicil. The testator must have knowledge of the general extent of one's assets, must have knowledge of the natural objects of one's bounty, must have an understanding of the impact of the dispositions that he makes, and finally must be free from any delusions. So just to remember that, it's wills, assets, bounty, impact, and delusions, or mnemonically, WABIT. You can write that down. The fact that the fact of a suicide throws a wrench into the works, because the fact the mental health issues that arise or may be present where there is a suicide could touch on any one of those factors. However, it's clear from the case law that the fact of a suicide is not in and of itself proof of lack of capacity. The test in Banks and Goodfellows, WABIT, must still be applied, and the court will look at whether the factors that led to the suicide or were present when the suicide was committed impacts on any of those 5 factors. The fact of the suicide is admissible and will be looked at, but it's not conclusive. There are numerous cases where the court has dealt with the fact of a suicide and found that notwithstanding that, testamentary intent existed. One example is an Ontario case of Codet and Young. There, the deceased left a suicide note, and in that note he left his entire estate to his son. Unfortunately, the note wasn't signed and therefore didn't meet the technical requirements under the Succession Law Reform Act. However, the court was able and in fact relied on the note and used it to find in favor of a son who made a claim for dependent support and found that there was an intent to benefit the son. The court said, quote, "While the note does demonstrate that the deceased was suffering from severe grief at the time, the clarity of the note and the lack of any other evidence to the contrary leads me to the conclusion that the deceased did not lack mental capacity to know what he was writing." Another case on point is the Quebec Court of Appeal case of Girard and Cloutier that it affirms the presumption that a testator is sane and capable of making a will and disposing of property by a will, and the mere fact that the testator committed suicide wasn't sufficient to displace that presumption. In the case of suicides, we know that consumption of alcohol by a testator can lead to a finding of a lack of capacity, and in the cases of suicide, alcohol use or chronic alcohol abuse can be a contributing factor towards suicide. High consumption of alcohol leads to higher suicide rates, so that is another factor that may affect a finding of testamentary capacity. However, it's not enough to show that the suicide victim was an alcoholic or drank heavily in order to show lack of testamentary capacity. An important case on point is the Pomeranic estate case of 1979 that's very illustrative of the considerations that the court will take into account in looking at a suicide note and whether the deceased had testamentary capacity. There, the deceased had a very unhappy home life, and this led to her drinking. The drinking led to a separation from her husband, which led to even increased drinking, we're told. She ultimately took her own life after leaving a suicide note that made provisions for family members in distant cousins in Germany. The court had to consider whether she had testamentary capacity at the time she left her suicide note. In determining whether the deceased had testamentary capacity, the court looked at the dispositions made by the deceased and whether she had reason for those. The court felt that in light of all of the circumstances of her life and the alienation from her immediate family, that the distributions that she made weren't unreasonable, and therefore she was able to, she did have testamentary capacity at the time she made the will. Other factors that the court considered, and remember, all of the factors of the deceased must be looked at, include the fact that the handwriting note that she left was legible, and the court concluded that she probably wasn't drunk then at the time that she made the note, although she had high levels of alcohol in her blood at the time of death. The important time is the time that she made the actual note. The court also relied on the fact that the deceased, before she took her life, had the wherewithal to put the note in her purse, and she hung the purse on a latch outside of the house on a back gate. The deceased took her life by setting fire to her basement, and the court felt that because she was able to have the mental capacity to safeguard the will, that she probably had the mental capacity to make the will. The court, as I said, also looked at the nature of the gifts, and that's a very important factor that the courts will consider. The nature and extent of the gifts made in the will be looked at. The courts will be more favorable and more likely to find testamentary in capacity if the gifts are said to be not unreasonable. Other factors that can impact upon testamentary capacity and that are often present at the time of a suicide are depression and delusions. There are a few cases dealing with depression, and the fact of the depression must be such that it affects one of the Banks and Goodfellows factors. With respect to delusions, and I'll just touch on this quickly, the delusions, not all delusions will invalidate a will or lead to a finding of a lack of testamentary capacity. The delusions must have an impact on one of the Banks and Goodfellows factors. And there's a few cases that I've referred to in my paper. One is Brown and Thomas, where the deceased left out one of her daughters. The daughter said that the deceased suffered from delusions towards that daughter, and therefore the will was invalid. The court considered the circumstances of the deceased, and it seemed to say that the delusions weren't really delusions, and the daughter was, in fact, not worthy of receiving the estate. So that's one way to get around delusions, is to show that they're not delusions. One case that did find that delusions did in fact invalidate a will was the case of Onofchuk, where the deceased felt that his wife was trying to poison him over a number of years, and as a result of this, the deceased took to sleeping in the barn, boiling his water, sleeping in trees, just to be away from his wife. The court found that in those cases, that those delusions, and there was no suggestion that the wife was trying to poison her husband, those delusions, in fact, invalidated a will because they impacted upon the dispositions that the deceased wished to make. So in summary, I guess, we need to look at all of the circumstances surrounding the deceased. The fact of a suicide is a relevant factor, but it's not the end of the inquiry. And a neat tool that I came across in researching this paper is the use of what's called a psychological autopsy, where the circumstances of the deceased can be reconstructed by looking at all of the medical evidence available, interviewing witnesses, neighbors, friends, co-workers, family members, reviewing police files and autopsy reports in order to paint a picture of what the deceased was actually going through at the time of the suicide. And that can have a real illuminative effect on whether there was testamentary capacity. I've also touched on my paper on two other acts that are relevant in the case of a suicide where the deceased can't be located or the remains can't be found. One is the Declarations of Death Act and the Absentee Act. And in my paper I set out the requirements of making a finding or having the court find that there was a death, or short of making such a finding of absenteeism under the Absentee Act. Just in conclusion, the suicide is a major problem in our society today, and by reason of its prevalence, by reason of the broad and far-reaching effect it has on, obviously, the victim, their family, and friends and co-workers, but it also has a significant effect on the area of estates. Thank you.
Thank you very much, Paul. So that brings us to the conclusion of the formal part of our program. And so for those who have to leave, we wanted to give you that opportunity. Otherwise, we'll open it up to a question and answer session. And we've set up some mics in the room for those who are actually here in person, if you'd like to walk up to the mics. And we'll field any other emails that come in and address those questions as well. So do we have any questions? Wow, that's the shortest question and answer session I can imagine. So just a quick reminder that in wrap-up, to please feel free to visit our blogs and our podcasts. You'll access those through our webpage. And thank you very much for joining us. We look forward to seeing you on January 13th at our next next Hull and Hull Breakfast series. Thank you.